Welcome back, business law students. This week we're talking about Chapter 12, and that is the agreement concept of a contract. Is there an agreement? Okay. In talking about that, we'll of course talk about what has to be an element agreement, what is an offer, and when it can be terminated or pulled back. How does an offer have to be accepted? Electronics, paper contracts. Okay. Now, first of all, let me share this real quickly. You know that I really don't like the way the text outlines or defines contract, but in any event, they say mutual assent, offer acceptance, voluntary consent does not require writing. That is so confusing to you guys, and it makes me so angry because in the course of two chapters, they've changed the definition. So I think a contract is offer, acceptance, consideration. To you, that's the three most important things: a valid offer, a valid acceptance, and consideration paid. All right, let's watch a video real quickly that goes over some of those things. Bear with me.
Now for something completely different, or maybe not that different. We've been talking about the move from promises to bargains to contracts. The basis of contract is mutual promises. But not every promise leads to a contract. For instance, promises in which the person who makes the promise, what in law is called the promissor, doesn't expect to find himself in court. And in a situation like the invitation to dinner, shouldn't end up in court. And you remember Leonard against PepsiCo with the Harrier jet. That's another example. By and large, and later on, we'll see some very important exceptions to this. By and large, the class of promises, serious promises, if you like, let's call them public promises, not private promises, or joke promises, or gift promises, the law goes further in that class and says, in order to be sure this is serious business, that the parties are serious about it, and that it's worth our taking our time in court, judges, and so on, it's best that the promise be part of a bargain. That is, a promise given for something. Here are two straightforward examples. I go into a store and pick up some goods, and I promise to pay for them. They've given me the goods, and I've given them my promise to pay. Fine, a contract. Or I go into an antique shop and see an old desk I like. I promise to buy it, to pay for it, and the shop owner promises to deliver it to my house next week. He's got to polish it up, and he doesn't have a delivery truck just now, and so on. For there to be a bargain, there has to be something exchanged, something given on each side. In the first case, the goods in the store, paid for at the checkout counter. In that case, it's a promise for a performance. I take the goods then and there, or it's a promise for a promise. Promise to pay for the desk and the promise to deliver the desk. Either way, there's an exchange. Now, the person who initiates the exchange can set the terms of the exchange. That's what makes him the offeror. I offer the exchange, and the other side, who sometimes in law is called the offeree, he accepts. And he accepts either by accepting through making a promise of his own, or maybe by an actual performance. Now, when he says, a promise of his own for him to say, ah, yes, that counts as a promise. Will you promise to do this? Yes. By the way, it could be a performance in return for a promise. So I can give the antique dealer the $500. That's the performance. And he can promise to deliver. That's a performance for a promise. Either way, it's bilateral. And the contract is formed when the offer is accepted. What happens if I offer to buy this desk, this beautiful old desk, and I say, I'll buy this desk for $500. The antique dealer says, I'd be glad to sell it to you for $750. Is that a bargain? Well, it obviously isn't. Imagine if the buyer was somehow compelled now to pay $750 and get the desk. That wouldn't be right at all, because the buyer, the offeror, has stated his terms. I will promise to pay $500 for the desk. But I haven't offered to pay whatever you charge. That would be a ridiculous thing to do. And that illustrates that in order for the antique dealer to accept the promise, he's got to accept the offer I made. He can't accept some other offer that he might wish I had made. And the way that the law of contracts puts it is the offeror is the master of the bargain. That sounds rather dramatic, but it's only common sense. How could it be otherwise? How could it be otherwise than that the bargain is whatever the person who initiates it proposes and what the person to whom it is proposed accepts? If the person accepts something else, then obviously there's no bargain. And the idea that I would be bound just by walking into the store and offering something to then have to pay a great deal more is not the model of an exchange that we've been talking about.
All right, I'm not sure why Professor Freed had a pathological avoidance of the term offer, but basically you'll see he was talking about the acceptance really generally needs to mirror the offer, whatever you've offered. There's another YouTube here that I'm going to have you guys watch on your own. It also talks more in depth about offer and acceptance. So after you return from that, we will move on to the next page. Bear with me. Now, let me ask you this. After you've had a chance to see both videos, and you know that an offer has to be definite, it has to be clear, it has to manifest intent to be a formal contract offer, would you find any of the following to be formal contract offers? One, I'm thinking of selling my car for around $10,000. No, it's not definite, nor does it manifest the intent in the present to sell my car. Number two, advertisements. This one, when I first learned this, made me so angry. Um, there's a whole line of cases that say that advertisements really aren't offers to sell. Well, we all know they are, but because of a printer's mistake in newspapers back in the day, this is where the cases arose. Some, instead of this car is $20,000, the newspaper would say this car is $2,000. And then everybody go and say, I'm going to sue you if you don't sell me that, $20,000 car for 2,000. And so the courts have had to say, nah, ads are just invitations for customers to come in and offer to buy. Statements of future intent. Oh, I'm probably sell my house next year. That's not a formal offer with specificity to be in to bind myself now. Preliminary negotiation, same thing. You guys are going to see this when you're looking at buying a company or looking at a supplier, blah, blah, blah. You probably do what's known as an LOI, letter of intent. term sheet, etc. And it tells the guys basically on each side on the deal, we're looking at doing this. Well, under contract law, that is not a contract offer and acceptance. That is, this is what we're thinking of doing, but we will replace that with a formal contract. That just gives you enough information to let you know if you're interested in proceeding with the negotiations. Next, request for information, request for quote, etc. You'll often see your customers, big customers especially, might send you an RFQ, which is a request for a quote, and they'll say, what's your best bid on such and such? And you go back with your bid and say, I bid for $5 million to sell exactly what you quoted. Well, you submitting the bid is not accepting their offer, unfortunately. The offer still has to be them issuing a purchase order after that and you accepting the purchase order. Okay. Social or casual statements. Yeah, you see those. That's not a legitimate, serious intent to be contractually bound. Now, once we've talked about the offer, you see the terms I've been using. Offer has to be serious, has to be definite. We're talking about this car, this model, this price, da 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 da. And it must be communicated to the other person, the offeree, of course. Well, how can the other person accept it? Words or conduct? Well, if you say, I'll pay you $500 if you paint my fence, and I don't sign a contract, but I paint your fence, then I have accepted your offer by performance, performing that painting task. The acceptance must be unequivocal, communicated back to you, the offeror. It must be timely. Let's say you send out a quote and say, this is good for 30 days. Well, I come back 60 days later and say, okay, I accept it. Well, it wasn't timely. And then the mode must be proper. If you say you must advise us by acceptance on our website platform, but then I just sent you an email, that's not the required mode to respond to the offer. Here's kind of an interesting little question. You go outside your home and somebody's posted a bunch of advertisements saying, hey, we'll give you a bouquet of flowers every week for $45. You don't respond, excuse me, and the florist goes ahead and gives you a bouquet of flowers. Well, that's not legit because silence was not consent. All right. Now, what about if an offer is out there and then you change your mind? You, let's say, you say, Professor, I have gold. My grandma died. She's got some gold, and I'll sell it to you for $1,000. I haven't responded yet, so I haven't accepted your offer. And in that week, a week within the week after, gold doubles in price. Are you stuck selling it for half its value? Well, before I accept, you can revoke. Put it in the same way. Call me, writing, however you gave me the offer, and revoke it before I accept it. Some things are called irrevocable offers. Usually it's more like this offer's valid for 30 days and it won't be revoked within the 30 days. Rejection, if you say $1,000 and I say no, thank you, obviously that's a rejection. So the offer is no longer valid. Finally, I might say, how about 750? Now, here's an important part of contract law. I have effectively rejected your $1,000 offer for gold, and I have made a counter offer. So my offer now becomes the offer. And then, so we start the whole game over. Now I'm the offeror, and it's up to you to decide whether to accept my new offer or not. Those are different ways in which an offer can be terminated, right? There's a couple of others, lapse of time. we talked about that. It might only be valid for 30 days. A fire burns down the house you were agreeing to sell. Well, there's nothing left for the contract to apply to. Um, I'm going to paint your portrait, but I die after you accept. Well, by operation law, you can't force a dead person to paint your portrait, etc. Supervening illegality, we've talked about that. Pandemic, or in this instance with illegality, like sanctions against another country. You can say, yeah, we agreed to this, but I can't do it because it's against the law now. So that would terminate an offer. All right. What about, do contracts have to be in writing? Heck no. Probably quite often you do electronic contracts, and there's a bunch of law I'll show you in a minute, but that says they're just as enforceable as if you go into a bank and sign a contract. Okay. You do contracts every day on your computer. Couple of things that to look at. There's so much more in a contract to be considered with, but when you are signing a contract digitally or otherwise, look for choice of law, which means what state's law applies, because different states might interpret the contract differently. And forum selection, like a credit card, will require you to go to Delaware to arbitrate any dispute you have with them. That's known as a forum selection, where you have to go. So be aware of those. I'll let you read these, but these are just the various U.S. and international laws making digital contracts applicable. And this is just the application of the Uniform Electronic Transaction Act, both state and federal. All right. That is it for this week, my friends. And I will see you during our next lecture. Thanks for your attention.